Jurisdiction of the Supreme Court. The Supreme Court has both original and appellate jurisdiction. The Supreme Court has exclusive original jurisdiction over petitions for certiorari, prohibition, or mandamus against the Court of Appeals, the COMELEC, and the Commission on Audit. The Supreme Court has original jurisdiction, which means that the cases are directly filed with the Supreme Court in the first instance without passing through any other lower courts. Under Article 8, Section 5, Paragraph 1 of the Constitution, the Supreme Court exercises original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. In other rules, the Supreme Court exercises original jurisdiction over writs of amparo, habeas data, and environmental writ of kalikasan. The Supreme Court has appellate jurisdiction to review, revise, reverse, modify, or affirm final judgments and orders of the lower courts in all cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. The Supreme Court has appellate jurisdiction over all cases involving the legality of any tax, impost, assessment, or toll, or any penalty imposed in relation thereto. The Supreme Court has appellate jurisdiction over all cases in which the jurisdiction of any lower court is in issue. The Supreme Court has appellate jurisdiction over all criminal cases in which the penalty imposed is reclusion perpetua or higher. And finally, the Supreme Court has appellate jurisdiction over all cases in which only an error or question of law is involved. So let us discuss the jurisdiction or the appellate jurisdiction of the Supreme Court over all criminal cases in which the penalty imposed is reclusion perpetua or higher. Take note that in People v. Mateo, GR numbers 147678-87, July 7, 2004, the Supreme Court actually held that while the fundamental law requires a mandatory review by the Supreme Court of cases where the penalty imposed is reclusion perpetua, life imprisonment, or death, nowhere, however, has it proscribed an intermediate review. If only to ensure utmost circumspection before the penalty of death, reclusion perpetua, or life imprisonment is imposed, the court deemed it wise and compelling to provide in these cases a review by the Court of Appeals before the case is elevated to the Supreme Court. Okay, the Supreme Court held that a prior determination by the Court of Appeals on particularly the factual issues would minimize the possibility of an error of judgment. If the Court of Appeals should affirm the penalty of death, reclusion perpetua, or life imprisonment, it could then render judgment imposing the corresponding penalty as the circumstances so warrant, refrain from entering judgment, and then elevate the entire records of the case to the Supreme Court for its final disposition. The Supreme Court, under Rule 45, or appeal by certiorari, has appellate jurisdiction over the regional trial court on questions of law. So in all cases where only questions of law are raised or involved, the appeal shall be to the Supreme Court by petition for review on certiorari in accordance with Rule 45. Likewise, the decisions or final orders of the Sandigan Bayan are reviewable under Rule 45 or appeal by certiorari to the Supreme Court. And finally, the Supreme Court also has appellate jurisdiction over decisions or final orders of the Court of Tax Appeals or CTA en banc. Question: what is the remedy against the decisions and final orders of the Sandigan Bayan? The decisions and final orders of Sandigan Bayan are subject to appeal by certiorari or Rule 45 under the Rules of Court. The Sandigan Bayan decisions and final orders shall be appealable to the Supreme Court by petition for review on certiorari, raising pure questions of law in accordance with Rule 45 of the Rules of Court. Whenever in any case decided by the Sandigan Bayan, the penalty of reclusion perpetua, life imprisonment, or death is imposed, the decision shall be appealable to the Supreme Court in the manner prescribed in the Rules of Court. Next question. Can a petition for certiorari under Rule 65 be resorted to? The answer is no. As is clearly provided, the sole and proper remedy available to obtain reversal of the decision and resolution of the Sandiganbayan is to appeal pursuant to Rule 45 of the Rules of Court. The existence and availability of the right of appeal prohibits the resort to certiorari because a requirement for the latter remedy is there should be no appeal. Now, what is the remedy against the decisions and final orders of the Court of Tax Appeals en banc? Decisions and final orders of the CTA en banc are subject to review by the Supreme Court under Rule 45 or appeal by certiorari. A party adversely affected by a decision or ruling of the CTA en banc may file with the Supreme Court a verified petition for review on certiorari pursuant to what rule? Rule 45 of the Rules of Court.